just prior to this procedural conference, held a public statement hearing. There are a number of people that have requested party staff that spoke during the public statement hearing and provided reasons during that hearing why they believe that an evidentiary hearing and other procedures are necessary in this case. Given those statements, I'm going to take the transcript of the public statement hearing and incorporate it by reference into this procedural conference as a request from those persons who identified themselves and are on the party list maintained on the Department of Public Service website as reasons that they believe that further procedures need to take place. They've been identified on that record. Now I'd like to turn to the attorney for the developer. Mr. Fidel, can you tell us who you are and spell your name for the record, please?
Good evening, Your Honor. The firm of Reed and Laniado, R-E-A-D and L-A-N-I-A-D-O by Constantine, K-O-N-S-T-A-N-T-I-N, Fidolny, P-O-D-O-L-N-Y.
And Mr. Goodman?
Good evening, Your Honor. This is Jay Goodman, J-A-Y-G-O-O-D-M-A-N, Assistant Counsel for the New York State Department of Public Service.
Okay. What I understand of this project and the developer's petition, Hill Wind's petition, is that the project has undergone review by the town of Villenova, which acted as a lead agency in the state environmental quality review that was done for this project. The petition indicates that the developer has received all required local and most state permits, that it is in need of a CPCN, and that was discussed actually by Department of Public Service staff members during the review. So I take it from that, Mr. Goodman, that the Department of Public Service was active in the review of the environmental impact statements.
That's correct, Your Honor. My understanding is that the Department of Public Service staff provided comments during that period.
Okay. What I understand of this project and the developer's petition, Hill Wind's petition, is that the project has undergone review by the town of which acted as a lead agency in the state environmental quality review that was done for this project. The petition indicates that the developer has received all required local and most state permits, that it is in need of a CPCN, and that was discussed actually by Department of Public Service staff members during the review. So I take it from that, Mr. Goodman, that the Department of Public Service was active in the review of the environmental impact statements.
That is correct, Your Honor. My understanding is that the Department of Public Service staff provided comments during that period.
Mr. Goodman, at this point, what has staff received from the developer in terms of the CPCN petition?
In addition to materials that have been filed through the Public Service Commission's and matter management DMM system that are publicly available, DPS staff has submitted some discovery to the developer. Some of the questions have been answered, and others were just other questions were provided recently, and we're waiting for responses to that. That is information that will not be. It is provided off the record, so to speak, and to the extent that information provided is considered to be relevant and necessary to be added to the record, that staff would appreciate an opportunity to make a filing in the record so that information can also be before the commission.
And how would staff make that filing? Or how do you propose that staff would make that filing?
In the recently concluded case regarding Hill Wind, after the procedural conference similar to this, Your Honor issued a procedural ruling which established a period for discovery, followed by an opportunity for parties to either file a statement of position if they wanted to, and or also file supplemental information. And I think that procedure worked well in that setting, and I think it could be appropriate.
And Mr. Goodman, the Department of Public Service Staff Council speak to the difference in this case, considering that all Hill Wind has gone through a secret approval rather than an Article 10 approval than Casadega. Are there any concerns that you have?
If I could just clarify, Your Honor, are you asking me to identify any concerns or speak to the differences?
Well, first, do you see any differences in the way that the Commission should handle this case, or that I should handle this case in terms of getting a decision to the Commission, or at least a recommendation to the Commission?
I think the two applications come up from somewhat different routes. The Casadega Wind project had gone through the Article 10 process. The siting board, which granted a certificate for that, in their order, they directed the applicant to also seek the Section 68 Certificate of Public Convenience and Necessity. But in that order, they narrowly limited the scope of review for the Public Service Commission application. This petition is coming up from a different environmental review process, where the State Environmental Quality Review Act environmental review process has been completed. There is a closed record on the environmental review, but that process did not result in an order binding on the Commission that would limit otherwise limit our scope of review. So I think there are still some areas which may be outside the scope of review in this application because the process already happened. But it's not quite as narrow as it was in Casadega Wind.
And you were here during the public safety hearing, correct?
That's correct.
Did you hear anything that gave you any concern about the process that's been handled so far, and that would require us to handle this case with more process than we did in Casadega?
My understanding is that the environmental review record, the secret record, is closed and that cannot be reopened. I do not recall hearing a factual issue in dispute that is outside of the scope of environmental review as part of an administrative hearing. Given that, I think that a similar process probably would be adequate in terms of an opportunity for discovery and the filing of additional statements or comments.
And was staff aware of the change in the proposal? And Mr. Petroni, pardon me if I get this wrong, but the way I understood it from the community members that spoke tonight was that the project was evaluated in the environmental impact stage as a project of turbines that were somewhat smaller than the ones that eventually were put into the final proposal. I think it was by a magnitude of approximately 100 feet. Was staff aware of that change?
I believe that it was your
And Mr. Pedoni, Mr. Goodman, if you give me a mic, Mr. Pedoni, did I get the facts right on that? How can you speak to the concern that was expressed several times tonight about heights of the turbines that were at first proposed versus turbines that were later proposed, or at least that a change of law took place to accommodate?
If I could refer to my notes, Your Honor.
Absolutely.
So the final environmental impact statement was adopted by resolution 2016
By the town of Hanover? As
by town of Villanova as the largest.
okay.
After that, permits for the facility were issued by Villanova and Hanover in December 2016. after that, so the maximum turbines that had been studied up to that point were 492 and 495 feet, respectively, for the two towers. In June of 2018, Bolt Hill applied to modify the special permits to allow for a taller wind turbine up to 599 feet. With that application, they submitted several studies, and the town of Villenova, I believe, issued a negative declaration and approved the modification. The town of Hanover did not.
The studies that were submitted, before we get to that, so if I understand your last point correctly, then that means that the developer will be using different height turbines depending on whether it's in Hanover or Villanova, is that correct?
Yes, Your Honor.
Okay. Did the information that was supplied with the supplement, with the proposal increase to 599-foot wind turbines, those studies include information about turbines of that height?
Yes.
What other agencies were involved in the secret review besides the two towns and Department of Public Service staff? To the best of your knowledge.
The DC was, I believe, and give me a second. Are you asking about specifically the amendment application to increase the height of the turbines?
Actually, I'm asking about the entire process. And very specifically, do you know that New York State Department of Agriculture and Markets was involved? Yes, could you please identify yourself?
Your Honor, yes, I'm Mark Lyons, Marklyons.
Thank you, Mr. Lyons.
Project Development. Department of Ag and Markets were noticed as an involved agency, along with the other agencies in the state. I don't believe any comments were received.
Okay.
But among the conditions of our permits are that we follow Department of Ag and Markets guidelines in our construction.
Right, of course. Okay. Mr. Pedoni, what permits are still required aside from the CPCN that you're aware of? And I know on the petition, there's pages 16 to 17 list a number of permits, some of which were received by the filing of the petition, and some of which look like they were potentially received in the interim between when the petition was filed and today.
I believe the wetlands permit, still outstanding, as are road crossing permits from the towns.
Now, to the community participants who have requested party status, as I said when we started this procedural conference, I heard all of your comments tonight, and I'm taking those seriously into consideration with any decision I make here about the process. That includes the information that I heard about the amendment of the certificate or the petition, the permit for the height. It also concerns all of the concerns that were expressed about the public officials that were involved in that process that was going through, and also with some of the concerns, the other one in particularly about the World Health Organization update to the guidelines. Hearing that, is there anything that any of you would like to add at this point? Ms. Riggle and Mr. Crowley, could you just give Ms. Riggle the microphone?
Yes, I am just really concerned about the supplemental environmental impact statement that the county planning board asked Res to do, and it looks like, with these 600-foot turbines, they're unprecedented in the United States as far as we don't know the long-term impact or the sound effects or anything like that. And like I said in my speech, they did not model low-frequency noise, amplitude modulation, wind shear, turbulence, lower frequency, vibrations. There's no vibratory threshold, for 65 dBA at the 31 or the 16 hertz, 31.5. And to me, that's just insane because the larger turbines produce lower frequencies. I mean, that's a proven fact. And these residents will be guinea pigs. The setbacks are 1,200 feet, and the decommissioning was not updated. Why did they use a 2016 decommissioning plan with 495-foot turbines instead of the 599-foot turbines? These people this town will end up holding the bag for decommissioning. It's not decommissioning. The $1 million posted bond, that's even legit, I don't know, will not be adequate. It would be like $7.5 million to decommission these, and that shouldn't be the burden of the township or the farmers that are hosting these. They don't have that kind of money. Just trying to think. The shadow flicker, why aren't they offering mitigation for that? Curtains and blinds don't work. That's horrible. 40+ hours of shadow flicker for over 28 receptors, 17 receptors, 30 to 40 hours of shadow flicker. New York State's policy is 30 hours, which to me is too much. I don't think anybody that's a non-participant should have any shadow flicker. And I just think they have to do another SEIS. I don't know how they could not be required to do that. These will have major impacts.
Ms. Riggle, you mentioned the setbacks. Are those from the residents or from the property owner?
From the residents. The town board adopted, Mr. Spitzer convinced them that 1,000-foot setbacks was adequate for 599-foot turbines, and Res has said in their modeling, other setbacks, it'll be 1,200 feet from a non-participating receptor. And I feel, and I know Mr. Twittrell feels the same, that it should differ for a participant. Why aren't there's innocent children, babies, elderly people living in these homes of the participators. They should not be exposed to levels that have negative health effects like this. And we don't know because we don't even know what the baseline, Hessler in 2008 did the original monitoring of the background ambient noise. You cannot find that anywhere on their website. It is like the hidden information. So how can you use the DEC mitigation?
What was the basis? Was it you that made the comment that the background noise study was done in 2008?
2008. That's 11
what was
years
the
ago.
basis for your information on that?
That's on their site. It refers to Hessler's study done in 2008 when the wind companies started coming around back then. It was a different LLC, but you cannot find it. I have scoured their website. They refer to it, but I would like to see the methodology on that, and that is such a vital, important thing to use as your baseline to see if you're, adhering to the DEC mitigation guidelines of 10 above, deserves mitigation. And I believe these at 50 decibels above. We live in a similar environment, and our ambient L90 is 20 to 25 decibels at night. And so these people with a 50 decibel noise limit could be exposed to very intolerable noise limits, according, to anything you read from the DEC, or just like they're saying in Arkwright, these people leave their homes at night to sleep. That is not right. And these are 600 feet. Arkwrights are 495 feet tall.
Right. I'm concerned about the baseline study, though. What was the basis for your statement, if you know, why it hasn't been updated since 2008?
I don't know.
Okay,
That's why
okay.
I'm saying it should
Right.
have been.
Well-
Oh, they took the substation out too. That's one thing I'd like to ask Mr. Lyons. Mr. Lyons, Hanover voted against the amendment. Villanova approved it, and Mr. Lyons dangled a carrot kind of to the town of Hanover. If they approve the 600-foot turbines, then we will remove the substation on Hurlburt Road, and we will do overhead, or underground, I'm sorry, take out the 115 kV overhead and put it 5 miles underground. Well, we're still wondering, because it was a split vote, which way is it? And the Army Corps of Engineer, I asked them yesterday, they still have not given them their permit. Which application was submitted to the Army Corps? Was it the amended application? Because it's going to be a huge difference, underground versus overhead. Underground trunching has a lot of permanent impacts that overhead doesn't. So that needs to be considered by the Army Corps, and maybe Mr. Lyons could answer that if Hanover is going to have the substation removed and underground wires.
Well, yeah, but actually that itself is an issue between the town and the developer. It's actually not necessarily improper. I understand your viewpoint and the characterization of it, but it's not necessarily improper to offer to change one part of a project to accommodate another project. I mean, that's an offset that could have very legitimate reasons. There are some things that you raised, though, that I do have some concerns about.
Your Honor, one thing too, I'm getting sidetracked here, but the substation was removed for their upgraded amendment application. They took the substation out. Well, if the substation's going to be there, which it looks like because Hanover denied the application, the amendment, so if that substation's there, they have to redo the PNIA. I mean, it was so faulty because the low frequencies absent from there, wind shear, amplitude modulation, turbulence was not studied. It was a real cursory overview, but they took the substation out. That's got to be modeled in there.
Okay, I appreciate your viewpoint. Mr. Twitchell, did you want to add anything that Ms. Riggle didn't mention?
Yes, Your Honor. I have a question about how you would look at that our concerns for safety, for the noise rulings here. Because when we met in Sinclairville last fall for the CPCN hearing for Casadega, you informed us that there were several concerns that were expressed that were outside of your consideration because the siting board had already, ruled on them.
That's correct.
Okay, but here we have a case where there is no siting board, and the applicant and the town of Villanova have yet to completely, satisfy the rules for the seeker. So I guess my question boils down to under what grounds would you not admit our concerns for safe turbine noise?
Well, in this case right now, I agree with you. There is a difference between what happened with Casadega because of the Article 10 that basically preclude the commission from deciding certain issues. But there's still some sort of overlap that takes place here in the secret process, and I need to go back and do some research on what exactly is the commission's role when a project has gone over secret versus when it's gone over Article 10. And I do have some concerns, which leads me to a question that I had for Mr. Goodman, but I want to let you finish first before I get to that. So I hope I've answered your question, that the door is still open on any process here, and any ruling that I will make in this case on process will differ from Casadega in the sense that it cannot rely on preclusion through Article 10. It will have to explore SECRA and the relationship between SECRA and the Commission.
Thank you, Your Honor. That answers one question. I do have others, but perhaps they'll come in time as we
go down the road.
Okay, I would like to ask Mr. Goodman, does DPS have a sound engineer on staff that is looking at this petition? Is Miguel working with your group for this?
Miguel is not currently working on this. If I could just go back to clarify my earlier statement to what you were just saying, your question to me earlier about the differences. My understanding is that the commission, to the extent that it would undertake some environmental review for this application, my understanding is that the review, where there's a closed secret record, that we cannot reopen and or do a duplicative environmental review. And that was the basis for my answer earlier.
Right.
I would also, like you, in terms of doing extra research, if there were a basis to take a look at potential impact, or also heard the concerns were raised earlier. I understand that some of the information, for example, the WHO study came out after the secret record had closed, and some of the concerns. My understanding has been that even though that came out after the secret record is closed, but before the commission is ruling on this, that the commission has to accept the secret record as it stands and cannot reopen it to look at those potential impacts. If my understanding of that is incorrect, it's incorrect, and if it's an issue that has been raised, so we're not opposed looking at it. However, I'm not aware right now of the basis.
Okay, I appreciate that. Mr. Pedone?
If I could just add, our position is that sound and noise specifically has been studied in the CEQA process, and DPS was invited to participate and did participate in that process, and that issue has been resolved. So from our perspective, the issue of sound has been studied and has been decided by the lead agencies.
Which is the town of Villanova.
Correct. Yes, sir.
Okay, your client.
Yes, Your Honor, thank you. I just thought I'd take the opportunity to clear up an issue that seems to be confusing, that does relate directly to comments that were made by DPS staff in the secret record. When the supplemental DEIS was done in January of 2016, the DPS staff, their comments, I think it's fair to say, were chiefly concerned with the noise and visual impacts associated with the Southern Collector substation that's been referred to here, and the overhead high voltage line that runs for about 5.7 miles. And it's in direct response to those DPS comments that we have revised our design to eliminate those facilities and to put the collection system underground to the point of interconnection, and thereby additionally avoiding about 3 acres in wetlands impacts and about 10 acres in ground clearing impacts. So all of this was taken into consideration by the town of Villanova as lead agency in approving the application that we made in 2018. But that is a design revision that we will stand by, and that is reflected in our CPCN petition. And again, it's in indirect response to DPS comments.
And as a representative for the developer, I would just like to hear your thoughts on the relevance of the update to the World Health Organization guidelines for noise, if you feel that they have any relevance to the project, or to the studies that appear and support the environmental impact statements.
Your Honor, this project was under secret review for a decade. And at all times, the project sponsors followed the pertinent law and guidelines associated with the project. And those were the sound standards in the town law. And as interesting or important as the WHO guidelines may be, they did not govern permitting of the project at any point in that time. I think it would have been fair to say if they had become governing, then it should have been pointed out to the developer, and we could have taken steps to ensure compliance with them. But with all due respect, it was not the standard that we were held to. It was not a governing guideline. I might say that in making our application in 2018, the taller turbines that were permitted by the town of Villanova are actually quieter than the lower turbines, and we have a noise study to prove that, and that was part of the record before the lead agency. So that I think they considered to be also a mitigating factor. But in answer to your question, the WHO guidelines and standards were never governed this project in its permitting process.
I appreciate that. I just want to let the community members know that when I say I appreciate that, I appreciate that it is the company's position. I have something now to think about with regard to that, and it doesn't necessarily mean I agree with it. I have not made up my mind on the issue. But it's important for me to hear what they have to say, given the amount of discussion that received tonight at the public statement hearing. So I do need to hear their side of it. I know that you very likely disagree with those statements.
Your Honor, if I could just add, it
Yes,
was
Mr.
the town's prerogative to ensure compliance with their existing sound code, which is what they did as lead agency in this case, in the supervisor. So to the extent we could have or wanted to adopt new guidelines, they should have done that to ensure compliance with those.
Okay, I appreciate that as well. Ms. Riddle?
Could I just ask Mr. Lyons to get this on public record? Are you?
Yeah, we need to hand the microphone over.
I know somebody from Hanover asked you yesterday, I think it was, or the day before, a friend of mine, about the substation removal and the overhead going to underground in Hanover, since they vetoed the amendment, and you told this person that you didn't know that it's, you're going to wait and see. So are you telling me that substation is going to be removed on Hurlburt? There's not going to be a substation. Is that what you're saying?
My understanding
overhead?
that those changes made to the final design proposal based on input from Department of Public Service staff, not necessarily from the town of Villanova or Hanover. Is that correct?
That's correct.
Okay, the answer from Mr. Lyons is that is correct. So
What's correct? There's not going to be a substation on Hurlburt?
That's correct. In response to the DPS comments and concerns, we have removed the substation from our plan.
right, and Mr. Lyons just represented it probably didn't pick up on the microphone. That it is correct that there is no substation there.
So, all right, thank you.
Yes, Your Honor. Returning again to the relevance of the World Health Association study of 2018, we certainly grant that the town and the developer weren't aware of those conditions. However, we are acutely aware that the Department of Public Service is advocating that developments elsewhere in the state will adhere to those conditions. And so our question is, under what grounds would the Department of Public Service approve a protective regulation for one jurisdiction, which is more or less protective than for another jurisdiction, given the fact that it's the same certificate granted by the same agency? Given the fact that it's the same certificate granted by the same agency.
Right, I appreciate that, Mr. Twitchell, and that was in the comments that I believe you made or someone made during the public statement hearing, and that is on my mind, the difference in project requirements. sometimes it does happen that there are different requirements in projects just because of the effects of time and developments in the law and things like that. And other times there's differences for a number of reasons, but that is something that I will consider when I determine whether any further process needs to take place in this case.
Thank you for that consideration. Can you cite an example where the Department of Public Service has actually granted a condition for noise regulation for one jurisdiction that is different than for another? Is that on the record?
There will be, if you look back at the old Article 10 cases, I'm sure you will find situations where not necessarily noise, but there are changes in law or recommendations that have taken place over the decades that those usually single-purpose power plants were being built, and over the decades that law was in effect, I'm sure there are changes that were made where one jurisdiction received certain protections and then another jurisdiction several years later received stronger or lesser protections based on changes in the law, but I don't have any specific sites to give you off the top of my head.
Thank you again, Your Honor. I can understand that the regulations change over time. Can you cite an example of the department's decision-making in terms of granting, updating, for example, if there were a new pollution standard, for example, whereby the department has asked a developer to modify the conditions to which they were originally granted on the grounds that there are new, standards?
No, I can't right now. Pollution standards would usually be handled by the Department of Environmental Conservation. But again, I think what needs to be kept in mind is that while this process was going on, there were certain recommendations and guidelines in place. The final action by the lead agency in the State Environmental Quality Review process took place prior to the WHO regulations or guidelines being updated, and that is something that I do seriously have to take consideration. And because had certain things taken place at different times, there could have been different outcomes, and it has some very persuasive effect that process was completed. However, I am very aware that we are going through this process now and that the Commission has some decisions that it needs to make with regard to issuing its certificate, some of which may be slightly different than what took place in Casadega. So,
okay, thank you.
Mr. Graziano.
On those turbines being 100 foot taller, Mr. Lyons states that they're quieter. Where can we find that information, and why isn't that a drastic enough change and not to justify another environmental study?
Well, that's a question that the Commission may consider is, was it such a change that it renders the secret process invalid? More realistically, that's probably something that the courts need to decide. I believe it was you during the public statement hearing that brought up the Article 78 proceeding, or was it Mr. Twitchell? Anyway, that is probably something that the courts are more equipped and better able to decide than the Commission when it comes to determining whether a change of that magnitude invalidates the secret process that the project went through.
And where could we find those results that Mark Lyons was telling us about?
Oh, I don't know. We can, if I determine that it's important information to have in the record, or if staff first decides that it is, staff can ask discovery questions on that and submit that. Otherwise, I can tell you that it's not as based on my involvement with Casadega Wind and looking at all the noise evidence that was supplied in there, it is not beyond the realm of believability that that comment is correct. By increasing the height of a turbine, you're increasing the cone of sound as it spreads out, and it's very possible that that could result in reduced noise. I don't know if that's true as a fact or not, but it's not something that, you know, it may sound counterintuitive, it may sound wrong, but it's actually something based on the experience that I had in Casadega that, and my involvement in that case, that leads me to believe that that may be an accurate statement. Again, that is either something that needs to be decided by the commission, or if the commission decides that it's out of its ability to consider that because of the secret process, then for the courts to decide potentially. But if you would like to talk to the developer afterwards, they may be willing to supply you with those studies. If they're not, then, you know, if staff doesn't pursue it, you can contact me either by phone or by email and tell me that you would like that information, and if I think it's important enough, I can order the developer to provide those studies for the record.
All right, thank you, Your Honor.
Your Honor, I have a quick question.
Yeah, this is Ms. Graziano.
Mr. Goodman said they closed the seeker application in 2016. Well, the 104 change in the height, 104 feet in the height, came in 2018.
Right, I think the final adoption of the SECRA final environmental impact statement was done in 2018, is that correct?
Yes, sir. The secret process ran through 2018.
Right, so the answer was that the secret process ran through 2018 from Mr. Lyons.
Your Honor, the 2018 amendment application that was referred to earlier has been closed.
Right, yeah, I did see that the 2018 environmental impact statement material has been uploaded to the Department of Public Service website. It is on DMM. I'm very familiar with that because some of it's locked in the sense that I couldn't print it out and I wanted to, but I can always request hard copies. That was just for my convenience of reading at a desk rather than my stand-up computer, but I made the sacrifice. But the information is there, and it is openable and readable by people who go to the Department of Public Service website for this proceeding.
Okay, thank you. I was wondering, because of the 100-foot increase that it came in 2018, probably coincides with the WHO's recommendations. Now, it was RES's prerogative to increase this height. Shouldn't they fall under the scrutiny of the WHO, since it's...
I don't believe that that's accurate. I think the World Health Organization updated guidelines came out after the final action took place on the FEIS by the town of Villanova. Mr. Podolny, is that correct?
Yes.
And what year was that?
Mr. Podolny said yes, that's correct. Even if it didn't, I think it's the developer's stance in this case that it was the town of Villanova's prerogative as the lead agency to consider that. And I understand your concerns with the town of Villanova and the town board. I heard that loud and clear tonight. So yeah, I'm just letting you know I understand both sides of the positions that are being put out here today.
Okay, thank you. I just, yeah.
I think at this point I've heard enough to consider for any ruling that comes out. I'm not going to make any ruling tonight on further process. It is something that I really need to seriously consider and look at with regard to the difference here, because this was the secret process versus the Article 10 process. And I assure you that any ruling that I make will explain my view on that question. So I can let you know that. Did you have a question? And can you identify yourself?
Margaret Bregel.
Yes.
Our location on Hurlburt Road is a rather major migratory route for birds, coming and going. And I'm wondering if the additional environmental reviews included the impact on bird losses with the added 104-foot increase in turbine height.
Yeah, I don't know the answer to that, but I do know that it falls under the same sort of question that I am left to grapple with over the next couple of days, which is, did the increase in height and the information supporting that increase in height, is that action that was taken by the town of Villanova, does that preclude the commission from considering, the effect of environmental concerns that are raised? Is that something that the court can determine might have invalidated that process rather than the commission? And it's something that I will consider seriously and issue a ruling on further process in this case after due consideration. So,
thank you, sir.
thank you. Mr. Goodman, do you have anything else?
No, Your Honor.
Okay, I just asked Mr. Goodman if he had anything else tonight, and he said no. And I think with that, we're going to call this procedural conference to a close. I will have a ruling that will be issued. It will be served on anybody who signed up for email for service. If you have not signed up for service by email for the commission documents in this case, it will be available on the Department of Public Service website. That website is www.dps.ny.gov. And if you go to that website and hit the link for commission documents or to search, you can search under the case number, which in this case is 18 for 2018, 18-E-0654. And Ms. Riggle?
Hi, Your Honor. I just wanted to add one thing. If people at the DPS are looking at the case record that you just stated the number for the CPCN,
Yes.
I'm just still questioning why RES has the Appendix O noise study from 2015 that had the smaller GE 116, 2.3 megawatt and the Vesta 110s instead of the ones that they're really planning on using. It's very misleading. I just wanted to point that out. If
Right.
somebody's reviewing that they need to look at the updated.
I think what that indicates, as far as I understand it, is that that's what the town of Villanova relied on in terms of making its final determinations in the secret process. Again, it's up to me and then the commission ultimately to decide whether that needs to be looked at in terms of how that relates to the commission's oversight in this case on environmental concerns versus whether they're precluded from doing that because of the secret process. There's no clear preemption authority in any statute like there was in Article 10, but that doesn't necessarily mean that it's not similar. But it doesn't necessarily mean that there was updated information. It just is evidence that that is what the town of Villanova considered when it made its final determination. Mr. Yeah, Mr. Podolny.
So what was uploaded to DMM was the entirety of the secret record, including the 2016 study, or including the older studies that had later been updated. So everything that was considered by the town of Villanova has been uploaded to DMM. So
Is there an updated noise study as well in the final environmental impact statement materials?
Yes, there is.
Okay, so what they're saying is that there were materials that were provided during the secret process through the entirety of that process from 2016 through 2018. So they included all of the materials, even the older studies that may or may not be relevant. they're making a representation now that there have been updated studies and that those are also included on the DMM website under the FEIS. I will take a look at that to verify, but I understand your point, Ms. Riggle. All right. Yes, Mr. Lyons.
Yes, Your Honor. Just to clarify, when the amendment was submitted in 2018, a revised noise study was done to study the taller turbines, and I believe several people referred to that study tonight. And it was part of the secret record that the town of Villanova relied on in rendering its decision on the 2018 application,
Right.
which was a negative declaration. But an updated noise study was provided and is part of that record.
Right, I appreciate that, and I will be taking a look at all of the final environmental impact statement material that's been loaded onto DMM. If I have any questions, I will just refer them to Mr. Podolny. Mr. Goodman?
Actually, I do have one request for Mr. Podolny or anyone that may be involved. I'm not sure if Mr. Riggle had mentioned the Article 78 that you alluded to earlier, challenging, I believe, the town's secret process. I don't know what the status of the litigation is. I don't know if there's a possibility that there will be a relevant ruling from the judge in that case in the next few months. But if there is, I would ask for it to be brought to my attention.
Right, I would appreciate that as well. My understanding from the comments that were given tonight was that it was filed, but that no action has been taken on that yet. Is that correct, Mr. Podolny?
Yes, sir.
And Mr. Podolny, for the record, indicated to me, yes, that is correct.
Because I mean, I know the relevance, I know it's probably obvious, but just to be clear, to make a finer point to what we were saying earlier, one of the questions I think you were saying is if it were to be found that there was a deficiency of whatever sort with the secret process, it's a question of, is that something that has to be remedied by the court through the Article 78, or, can the commission take action? It may be, hypothetically, for the sake of discussion, I'm not saying anything about what actually happened.
Right.
But if hypothetically we were to say that process was terrible and clearly deficient, it may be that notwithstanding that, the commission simply can't act because it's bound by that record, and the court has to act.
Right, I appreciate that.
If there's a ruling from the court that speaks to that, that would be very, I think it would be necessary to get that before the commission in time for it to make its decision.
Right, I have my own thoughts on the matter, but like any good judge, I reserve any comment on that until I've actually looked at the law and made sure that my thoughts and opinions are correct.
I understand. Thank you, Your Honor.
Thank you, and thank you everyone for your wonderful participation tonight. I very much appreciate the eloquence and clarity with which you presented your statements on the record in the public statement hearing, and this will be a wonderful transcript for the commission to consider. So with that, I'm going to go off the record and call the procedural conference to an end, but I will still be happy to discuss this with anyone who wants questions afterwards. Thank you very much. We're off the record.